This will be the first of three videos that I'll be doing on the topic of intellectual property. And I'm going to break them up into three just to make the videos small enough in size that I can upload them. And hopefully that'll make them a little more digestible as well. So intellectual property is a subject that maybe you have vague ideas about. You might not even know what it refers to at all. Intellectual property is a weird kind of area of property ownership. Typically when we talk about property, when we talk about owning things, they're physical things like a car or a house. And it's a lot easier to tell when somebody owns it, right? If there's somebody driving around in the car, usually you would be able to figure, well, that person either owns it or they have some arrangement with a bank that owns it and they're financing it or something. But you can tell that it's probably not some random person somewhere else that owns the thing because it's a physical thing. You can see whose hands it's in. You can see who's living in the house, right? If you want to know who owns a set of earbuds, then it's probably going to be the person who's walking around with them in their hands. But intellectual property doesn't have any physical existence. It's kind of imaginary in some ways. Intellectual property is property that exists in ideas. Now that's a lot more abstract than it needs to be, and I think when we get into some examples it'll become more familiar to you. So there's three, actually four really, we'll talk about big categories of intellectual property. The one that maybe you're the most familiar with is copyright. And maybe after that I would say probably the next well-known would be trademark. Patent, I would guess, would be third, and finally trade secrets, which is not even exactly intellectual property, would probably come fourth. So we'll talk about these one at a time and what makes them different. Often before people have heard an explanation of these different types of intellectual property, they don't exactly know where the boundaries are between them. And that's not too far from where you'll probably end up at the end, because there are some blurry boundaries between these concepts. They overlap, as you see in that diagram. You can have something that has both a trademark aspect and a copyright aspect, and you can end up with situations where a company or a person will be trying to claim one type of intellectual property, but a court will overrule them and say, well, you only have this other part. And we'll see why that's important when we get into them. So the first one we'll look at is copyright. Copyright is really, the origins of this go back to when you would have somebody write something, some creative work, which is kind of the original idea. They would write down something, and the goal was that copyright would protect the right of the printer to be the only person to copy it. You can maybe see how this would be necessary economically. Let's say you're a person who writes a story, and if there wasn't some legal ownership in allowing only one person to print it, then if you try and sell that story to some publisher, and they know, well, as soon as we publish it, some other person could come along and just take your story and print their own copy of it without paying us anything, then there's no point in me paying the author of this creative work anything at all, because I can just steal their idea right away. So the whole idea of a copyright, it's specifically focused on the printer, but without it focusing on the printer, there's no way that the money can go to the author of the work. It's important for you to understand, because often you'll hear people walking down the hallways and somebody will come up with an idea and they'll say, oh, copyright, copyright, my idea, I had it first, can't say it. Technically, copyright doesn't apply at all to ideas. It only applies, and it's the first bullet point on the page here, it only applies to fixed expressions. That means the idea has to actually be nailed down in writing or in some other medium, right? If you describe some picture of something, that's not enough. You have to actually paint that picture to be able to claim copyright in it. So copyright doesn't have to be in writing, it has to be in some work that shows originality. That can be a written story, that can be a painting, and we can also see that it can be things like sound recordings, right? It can also be even in computer code or in software. So when you're dealing with software, very often you'll see that the right it'll be protected under is through copyright. In order for copyright to apply, there has to be originality to it. It can't be just something that's ripping off an idea that's already out there. And most importantly, the last point here is that there's a defined end to copyright. Copyright doesn't last forever, right? Like if you wanted to, you could take one of Shakespeare's plays and print it up in a book and sell that book, and you wouldn't have to pay like Shakespeare's descendants, his great 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 granddaughter or anything. You wouldn't have to pay her anything because copyright has expired. In Canada, copyright for most types of expression lasts the full life of the person who's written the thing, and then a further 50 years after their death, so that they're able to bequeath some wealth, some value to their descendants. But you see that ultimately the value tied to the ideas in copyright runs out. It doesn't last forever. Depending on the country, it'll have a different duration. That's why I specify here that in Canada it's the life of the author plus 50 years. In other countries, it could be slightly different, and for different types of expression, it's not always the same. Now, an important distinction between copyright and trademark is really the philosophy behind what each of these is trying to protect. You see there the picture in this slide, that's a mark, a trademark. I don't know if you can see the little guy hammering in the picture there. He's hammering on top of a barrel. That's the guy who's supposed to be producing this item. Now, this guy looks probably like a silversmith. He might be producing cutlery of some sort. But the whole idea of a trademark, the mark is the mark of the guy or the woman or whoever who made it. And what's important is that if you are a craftsman, not somebody who's creative in any way, not somebody who's known for being original like copyright would protect, but somebody who's known for doing a really good job at producing physical things like silver spoons or forks or whatever it is, then when somebody wants to buy a fork made by you, they want to be sure it's made by you. And so they'll flip it over and they'll look and they'll see the trademark on it. That's the origin of the whole concept of trademark. It's a way of guaranteeing that whatever you're buying was actually made by the person who has this reputation for doing a good job, right? If I buy it from Ted the silversmith, I know that this fork is going to be good. It's going to last for 10 years without cracking or falling apart quickly because of this person's reputation. So ultimately, trademark isn't about creativity. It's about protecting reputations. So all fights that happen over trademark ultimately have to come back to, is this something that is supported by the reputation of the person it's claimed to be supported by? And so because of that, when the courts are trying to decide trademark cases, the big question they have is whether somebody looking at this product would confuse the product with belonging to somebody else, right? Like let's say, for example, Mike is really good at making, phones. Mike is a phone manufacturer. He's like a designer phone manufacturer. And people know that, oh, if you buy a phone from Apple, it's probably going to fall apart in 4 years, whatever it is. But when Mike makes a phone, this phone, it's got artificial intelligence in it. It artificially will update itself to new software. It'll invent its own software within 20 years. So if I see a Mike brand phone out there, I want to buy it. Now let's say Mikel, that's Mike with just a little tiny L after the E. Let's say he decides to make phones and try and convince people that they're actually Mike phones. Then what Michael would argue is like, well, no, it's not that I'm pretending that they're Mike phones. People look, they can see the little L next to my name. A judge might say, well, if I'm looking at this here, I see that your trademark looks a lot like Mike's. It kind of looks like you're trying to confuse people into thinking that your phones are really Mike phones and that they should pay more for them. So I'm going to decide that you're breaching Mike's trademark rights, and I'm not going to let you continue to use this mark, and you've got to pay him a whole bunch of money. Now, in order for a trademark to be protected, you see that the mark has to be distinctive. And what that means is it has to be that your trademark can't just be like an R that nobody would recognize, right? It has to be something about your trademark where people would see it and immediately say, oh, that's a specific logo that I can identify as being one particular company or one particular person. Right? That's why you'll see a lot of companies that are driving around in trucks or whatever. You'll notice they misspell the names of their companies because they have to. Now, they have to make the name not just be the regular name of the thing. They have to add a weird spelling onto it, a misspelling usually, in order for it to be protected by trademark. Now, the last bullet point here is the most important one, the biggest difference with copyright. Trademark never runs out. Trademark lasts forever. So if you can establish a trademark as being yours, as being associated with you, then it lasts forever. And we'll see in one court case that we'll look at that the fact that trademark lasts forever because your reputation just doesn't run out as a company. If you're always the same quality company, it makes sense that your name should still matter forever. Since it's not protecting your ongoing creativity of you coming up with something new, it's more protecting a long tradition, going way back in time of you doing a good job at making things as a company. Makes sense that trademark should last.